Have you ever entered the US illegally or overstayed your visa and are wondering whether you can still get a green card? Hi, I'm Andre Mayer, immigration attorney and an immigrant myself. And today we'll talk about how you can be a lawful permanent resident even if you came to the US illegally. Before I begin, please click the subscribe button and hit the notification bell to get updates on our newest content. Also, leave a comment down below on your thoughts or ideas of today's topic. Now let's get to it. First, what does being in the US illegally mean? I'm glad you asked. Unlawful presence means you're in the country without proper documentation or without going through the proper process. First, you might have overstayed a valid visa. That means you applied for a visa, were interviewed at an embassy or consulate, entered the United States legally, and then you remained in the US even after the visa had expired or your time in the US had expired. So your continuous presence is considered unlawful and will have repercussions on your immigration depending on the length of your unlawful stay. We'll look at this a little bit later. Second, you've entered the US borders illegally without going through the proper authorities or border inspection. Your illegal entry and stay in the US makes you an undocumented immigrant and will have implications as well when you apply for permanent residency in the future. Distinguishing between these two impacts the actions available to you when applying for your green card. Now let's discuss, how does the length of your unlawful presence affect you? The number of days for your unlawful presence can penalize you with a certain amount of time before you can return to the US. Specifically, if you overstayed in the US illegally for less than 6 months, that's 180 days, you may still be able to return to the United States if you apply for a new visa in your home country. Or if you had unlawful entry, you may be able to apply for a green card through the US embassy or consulate in your home country, also referred to as consular processing. If you stayed in the US, irrespective of how you entered, meaning you entered illegally or you entered legally and then overstayed, and that period of time you overstayed was more than 180 days, you're going to be barred for 3 years when you leave the US. If you stayed in the US illegally, meaning overstayed your visa for more than 365 days, you will be barred for 10 years. Take note that illegal entry after previous deportation can bar you from ever entering the US. But there are ways to avoid the 3 or 10-year bar. You can avoid them through a waiver of inadmissibility. Before leaving the US, you may apply and be approved for a provisional waiver. To gain approval, however, you will have to prove that your immediate family, meaning a parent or a spouse who's a US citizen, or not immediate family, just close family, so parent or spouse who's a green card holder, that they will suffer extreme hardship if you leave and are not allowed to return. It's best to consult with an immigration attorney if you plan to apply for this waiver to better assess your situation and give you the information you need on the necessary steps. You don't want to find you have a problem once you've left the US. Now, what are the different ways to apply for a green card even after having a lawful presence? Well, provisional unlawful presence waiver or a waiver is one way. But let's talk about 7 other ways. First, marrying a US citizen or lawful permanent resident. Under immigration laws, you become an immediate relative after marrying a US citizen. And this should be a valid marriage or your application can be denied. Also, it's important to distinguish here between unlawful presence, which is a visa overstay, and unlawful entry, which is illegal entry. If you overstayed a previous valid visa, you may be able to apply for an adjustment of status to get a green card. That means you apply inside the United States. However, if you entered illegally, you will likely have to go through consular processing or have the application at the U.S. consulate in your home country. If you have any questions about your application for lawful permanent resident, leave a comment below or set an appointment on my website, undersmeckerlaw.com. Let's get back to the second way to apply for a green card after unlawful presence or illegal entry. And the second is applying for a U visa or a T visa. U visa is available for those who are victims of serious crimes or qualifying criminal activity, and there are 23. It includes violent crimes like murder, enslavement crimes like abduction, domestic violence, also sex crimes such as sexual assault, and crimes obstructing justice such as perjury and extortion. The violent crimes I see more often are violence, assault, domestic violence, or unfortunately, sex abuse, particularly of minors. It's horrific, but those are the more common ones that we see. On the other hand, T visa is available for certain victims of severe forms of trafficking in persons or qualifying family members of trafficking victims. Such forms of trafficking include sex trafficking and labor trafficking. Both grants lawful status up to 4 years in the U.S. and can eventually lead to a green card. But what of your inadmissible due to past immigration violations, like those who entered the U.S. illegally? Well, U visa, T visa include a waiver on Form I-192, and unlike other waivers, this does not require you to prove extreme hardship. But of course, these are reviewed and granted on a case-by-case basis. If you are approved, good news. Your inadmissibility will also be waived when you apply for adjustment of status in the future. Third is applying for an S visa. An S visa is possible for those assisting law enforcement as witnesses or informants with valuable information leading to the prevention, discovery, or conviction of a criminal or terrorist organization. This visa is not applied for by the petitioner, meaning not by you. It's federal or state law enforcement agency that's going to apply on your behalf. The same agency also eventually can request for permanent residence of the S non-immigrant on their behalf, meaning they could do it for you. It's also possible through the visa to waive grounds of inadmissibility of the petitioner if you are a valuable witness or informant. I will warn you, it doesn't happen often. Fourth, applying for asylum. You may also apply for asylum if you can establish your fear of persecution under well-founded threats in your home country. However, this should be applied within 1 year of your unlawful entry of stay. There are exceptions, but that's the general rule. You can check out our other videos to know more about applying for asylum, as well as the new protocols for asylum under the Biden administration. Fifth, applying for special immigrant juvenile classification. This is possible for those who have suffered neglect, abuse, or abandonment and are subject to state juvenile court proceedings, meaning you're underage, you're not married, and it's your parents, or at least one of your parents, that caused you neglect, abuse, or abandonment. And when granted such classification, you will ultimately be able to apply for a green card through an adjustment of status. Take note, there are some grounds for inadmissibility that do not apply to those with SIJ status. These include unlawful presence, presence without admission or parole, and documentation requirements for most immigrants. It is, however, best to evaluate your grounds of inadmissibility, if any, with an experienced visa attorney to assess which waiver or form of relief would best apply to you. Sixth is self-petition for VAWA. Under the Violence Against Women's Act, VAWA, immigration provisions, those who have been subject to extreme cruelty or battery from a U.S. citizen or LPR spouse, parent, or child may self-petition for legal status. An approved VAWA immigrant visa can lead to a green card despite your illegal entry to the country. VAWA self-petitioners and beneficiaries are exempt from all of the bars, or almost all of the bars of adjustment. If you are inadmissible, except for grounds such as public charge and entry without inspection, which does not apply to VAWA self-petitioners, you can still explore applying for a waiver or another form of relief. VAWA, like a U visa or a T visa, has a built-in waiver to it. Lastly, requesting cancellation of removal in immigration court. If you are facing removal proceedings or arrested by U.S. immigration authorities, you may be able to request relief, avoid deportation, and get a green card. But it can be extremely difficult to prove, and you have to be put into removal. There's a variety of requirements. The hard, you've been in the country more than 10 years, person of good moral character past 10 years, not having committed a crime that would disqualify you, and being able to show extreme and unusual hardship, exceptional and extremely unusual hardship to a qualifying relative that's a citizen or lawful permanent resident, parent, child, or spouse. So it is a higher standard than the extreme hardship waiver. And you're going to have a trial in front of a judge, and that judge is either going to give you a green card or deport you. So it's best to undergo this request with the help of an expert immigration attorney that can help you build a strong case and guide you thoroughly. And that, folks, summarizes the options you have to still get a green card, even if you came to the U.S. illegally. Remember, Various factors can affect your case. Call us today to schedule a consultation with Anas Mecher Law if you're uncertain about what next steps are best for you. If you find this video informative, then like and share it with your friends who are also applying or are considering making an application in their immigration journey. If you have any ideas for future videos or would like me to talk about a particular immigration-related topic, go ahead and let me know in the comment section below. Until next time, stay healthy and be safe.